Hello. In this clip from our Justia webinar, Understanding Loan Transactions for the Non-Finance Attorney, Jake Rome shares some tips and recommendations non-finance attorneys can implement when dealing with loan transaction processes to help their clients better. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So here is where we're going to get to the bread and butter of the presentation. This is the important stuff. So here's the practical advice that I came up with for non-finance attorneys acting as counsel to borrowers. So the first big thing is know your audience. This kind of goes back to the Laser Pro versus attorney prepared documents that we came up with. That can give you a little bit of a window into the mindset of the banker who is behind the deal. If they're using Laser Pro, understand, like I said, that probably means that they don't have outside counsel assisting them. They may have in-house counsel whose basic job is to just kind of do quality control or on the actual documentations, but they're not going to get into the nitty-gritty of negotiations. First big one. If your client happens to be borrowing from a governing agency, such as the SBA, Fannie Mae, Freddie Mac, or HUD, know that the ability to negotiate loans is also going to be limited. Those are big bureaucracies. They don't like to move with a lot of alacrity. They don't pivot very well. It's not a dig against them because they do offer great financial products, but just know that they're going to be very limited. They have their preferred forms as well. Those have been, again, fed up the chain of command and approved by a process that involves a lot of red tape. So they're not going to negotiate too much, maybe a little bit on the margins. The second big picture item would be to confirm every business point that you're able to. This is a big one because I can tell you that even though we strive for perfection, banking attorneys, we are human, so there are some mistakes that can be made. In my experience, I've not encountered a lot of lending attorneys that are trying to pull any quote-unquote fast ones. So if in your process of review you come across a discrepancy, always raise it. It's always worth asking. Sometimes, it'll be there on purpose, but typically not. We're very easy to work with. Especially for litigators, I find that this is good advice because they're not used to business transactions a lot. In litigation, it is adversarial. In transactional law, it is much more collaborative. We're both motivated to get the deal done. That's how we make our living. So always, raise your hand and ask. You may be asking, how do I know what to confirm? That will be where you should ask your client if they received a term sheet. Term sheets are basically, one or two sheeters that set forth all the things that I hit in the loan agreement when I said loan amount, loan type, maturity date, interest rate, even sometimes financial covenants will be in the term sheet. If your client didn't give you one, that's an important thing to ask because you can use that as essentially, a guidepost or a Rosetta Stone to just go through the loan agreement and check things off. Next big picture item, act as a liaison. So there are things that I, as lending counsel, just can't possibly know about your client. This is going to be things that you would be in a better position to ask about. A lot of times, if I get a batch of corporate documents, such as articles of incorporation or an operating agreement on a borrower, they might be a little bit stale, and I have no way of knowing. For a lot of commercial loans, typically, the process takes a while, so it could be anywhere from 3 to 6 months by the time that the deal is, all the terms are negotiated and gotten through credit approval with the bank, and there are a lot of changes that can happen in that interim time that I might not know about. For instance, something that we're encountering a lot these days is Israel just recently changed their tax laws. A lot of my clients will be, Orthodox Jews, and they will have family that they repatriate to in Israel, so it's caused them to all convert their LLCs into limited partnerships. I have no way of knowing which ones do unless the borrower's counsel tells me. So things like that happen all the time. You have management changes at a company, and now the board of directors looks totally different. All the officers look different. So here I am putting a certain name and title in a signature block. I have no way of knowing unless borrower's counsel tells me. So those are important things. And I think that, there are other things that you should be aware of as well, such as if there's a mortgage, whether it be a residential or a commercial property, always double check things like legal descriptions, PINs. There was a spell a few years ago when enhanced 911 was a big thing. That was when a lot of municipalities decided to renumber their city streets so it was all consistent throughout the city. So if there was a call on at a certain street or a certain parkway, police and fire would have a better idea of which way the numbers ran, even if they hadn't been to that area of town before. Well, I think it's a great idea. It's definitely worth doing, but it changes a lot of house numbers on old documents that may be pulled from the recorder's website. And I don't have any personal way of knowing that street number or even street name, because part of Enhanced 911 as well was renaming, if there was a Park Avenue and a Park Street, they would change the name as one of them. So I have no way of knowing unless borrower's counsel has a dialogue with his client and lets me know. Another important way you could act as a liaison is just from a sheer due diligence process. And this benefits not just me as lender's counsel, it benefits your client. So ask thing about, in terms of any property that's been owned, has there been any environmental site assessments done recently? This is important because if the answer is yes, and I don't know that, then we can actually add that information into the loan document. So we'll carve it out of what's called an environmental indemnity. So a lot of times we want borrowers to take responsibility if anything bad happens on the property from an environmental standpoint, but we could say, we've reviewed the phase 1 examination that was done in 2016, and we're going to allow a carve out from those environmental indemnity obligations for everything that's contained in that report, and we'll incorporate it by reference. So that kind of information gathering on your part will do a lot of good for your client in terms of limiting the scope of their liability, limiting their risk exposure, etc. Another thing that you can ask about the property will be ongoing construction. This is important because in terms of when we get closer to the closing date, and if the lender is getting a loan policy on the property, from a title clearance standpoint, we'll need to know that construction has not been ongoing on the property for at least 6 months. And if it has, then there are steps that we have to take in the interceding weeks and months before closing in order to make sure that that's documented properly and that we're not going to create any undue risk for the lender or the title or your client. So I've had more than once these types of things spring up the week of closing, and it's kicked out the closing date for another 3-4 weeks. And at that point, nobody's happy because this was a solvable problem had we just had a heads up earlier. So those types of things are very important. We'll need to know who has been doing the construction on the property as well. If you can get us contact information for the actual contractor, that way we can get lien waivers in process and get all that documentation assembled over a title so they have a chance to review it well ahead of time. So these are just little things that you can do to better represent your client and to make them feel happy about your representation of them. Again, similar to the EPA site assessments that I referenced, recent surveys, recent zoning reports, there again, no way of knowing by looking at, let's say I get a zoning report, it's dated from 5 years ago. If there has been a zoning change in that municipality in the interceding years, I have no way of really knowing unless your client shows me some updated documentation to make sure that they are still grandfathered in or that the zoning regulation changes has not affected their property. If your client is cognizant that there have been recent zoning changes, but they don't know the answer, that's a good way to tip them off that you're going to want to figure that out now because it's going to be a problem. Once we get closer to closing, title companies are pretty good at their job, and they're going to figure out that those zoning changes happened. And if we haven't thought ahead and planned ahead, then again, this is one of those things that can delay closing. It's going to be a hard one for us to waive or just do post-closing. So they can always get what's called zoning letter from their municipality that will just basically say that, you are still in compliant as of this recent date. Again, if your client owns a piece of commercial property, one thing that changes frequently is tenant turnover. So we will want to know that the tenants that we underwrote against back, 3-6 months ago for our credit approval are still the tenants on the property, or if they're not, we'll want to know who the new tenants are, and we'll want to see copies of their leases to make sure that they're on similar payment terms as the prior tenant that we underwrote against. So again, it's always helpful to just have somebody who is not only in their client's corner, but is going to make the whole transaction run smoother by just keeping an open pipeline of information. I think a lot of attorneys, especially if they're not used to loan transactions, get a little bit intimidated by the loan portion of it and forget sort of the fundamentals of just representing and what constitutes good representation. So again, fact gathering, information and document gathering, and open pipeline of information. And this, again, is not only directed at my litigators, but especially at litigators. They tend to be very protective of information, which I think is very helpful in a litigation context, but maybe a little bit less so in a kind of more mutual goal-oriented transaction like a loan. So 2 major obligations that I wanted to touch upon that every borrower counsel should be aware of would be what's called the certificate and resolution and opinion letters. The certificate and resolution, pretty straightforward document, but it's for the authority to make sure that a corporate borrower has properly authorized the loan transaction. This is another area where you could do us a lot of help by reviewing the operating agreement or bylaws of a corporate borrower to let us know exactly what steps need to be gone through in order to authorize a loan transaction. You may remember from your BizOrgs class that certain major decisions taken by a corporation need to have authorization of not just the managerial staff, but some percentage of the actual interest holders or equity holders in the borrower. So sometimes borrowing a large sum of money would constitute a major decision for a corporation. If you don't do this part, we're going to do it, but a lot of times it will save us money and vis-a-vis your client money, because a lot of times borrowers have to pay the loan counsel's attorney's fees to just head off this at the pass and just say, hey, look, I'm going to direct your attention to Article 7 of this operating agreement. You'll see here that they need to get the consent of equity holders. I've already gotten that process underway. If you don't do it, I will find it, but it's very helpful and it's going to potentially save your client some money. The resolution part of that, again, just goes back to what I was just saying. The certificate part of that is going to be from a officer or manager of the corporate borrower. It's going to be like a 1-sheet piece of paper just saying that the articles attached here to as Exhibit A are still in effect, have not been amended, and are on file with the, let's say, my home state, Illinois Secretary of State. Attached here as Exhibit B are going to be a true and complete set of the bylaws or operating agreement, depending on their corporate form. Those have not been amended, or if they have been amended, all amendments are included as well. And then Exhibit C is going to be what's called a certificate of good standing. You can get these from the Secretary of State's website. If you don't know how to order one, ask me. I can either order it for you or I can tell you how to do it. There's no upcharge on a certificate of good standing. They're pretty cheap. So now let's turn to the opinion letter. This is a pretty important one. A lot of borrowers' counsels get the most cold feet when they reach the opinion letter because it is an attorney actually putting in writing their legal opinions in not indefinite terms. So we don't really like to do that. We love it depends. So I have a lot of sympathy for borrowers' counsels who have to write opinion letters, but unfortunately, it's just part of the game. That said, there is a negotiation that goes on between the lender, who obviously I want the most number of opinions and I want them to be as concrete as possible, and the borrower's counsel. This is an ongoing dialogue. So common opinions that are included in an opinion letter. And I guess we'll start with just saying why this is important and why it's used. It becomes part of the file at the bank. And basically, this is something, if the loan goes south and we find ourselves in court, we can go in and say, once the borrower starts contesting, oh, that's not my signature on there, we didn't properly authorize this transaction, we didn't know that the loan proceeds could only be used to acquire a building, we went out and bought a bunch of margin stock with it. We want to be able to protect ourselves against those things, obviously. So the opinion letter is basically our kind of mini insurance policy against that. So common opinions, proper formation of the borrower if they're a corporation. So that opinion is just from you as borrower's counsel saying the articles provided to the bank have been properly filed and are on file with the Secretary of State of X state. The existence of the borrowers. We have paid all franchise fees that are due under state law. We have paid to have our articles renewed, and they are renewed. And not only were they properly filed, but they are still in good standing. Proper authority. Again, so we're kind of going back to the things that I talked about with the certificate and resolution. So maybe you can start to see how all these fit together. So proper authority of signatory on behalf of the borrower. So that would be if the president signs all the loan documents, the president of the corporation, just saying that the president has been authorized by the board of directors or the shareholders to sign the loan documents as required under the bylaws. Proper execution would be just saying that, all the signatures of the president in the loan documents are actually his signature. You can see that most of these opinions are probably written in blood. So we've come across all the arguments that they make in court, and we kind of want to head them on. Enforceability of the loan documents and recordable documents. So this is just saying that if the loan documents are performed as they are written, then they would be the enforceable obligation of the borrower. That does not say that they're going to be enforceable if the lender fails to perform, just that if they are actually performed as written, they are enforceable. And recordable documents, that's just saying that we take a look at this mortgage or this assignment of rents, and it is in the proper form to be recorded in the Cook County, where I'm from, recorder of deeds. That there are no conflicts preventing borrower from executing and performing the loan documents. So this would just be basically, we've taken a look at the corporate records and the corporate minutes, and there are no off the records or off the books agreements that we have not disclosed the lender that would prevent the borrower from performing these loan documents. Another no conflicts opinion would be that there are not any state laws or obligations of the borrower to get authorizations from a government or a local governing authority prior to performing the loan documents, or if there are, that the borrower has obtained those consents from a government. That there is no pending litigation or threatened litigation against a borrower. That's a big one. We obviously do our due diligence on our own end, and we search all of the local dockets to make sure that there's no pending litigation in the municipalities where it should be filed if it's properly filed. But we obviously can't look state dockets and federal dockets for all 50 states. So we asked that the borrower's counsel just say, I talked to my client, they said there's nothing pending in Florida. That there are no circumstances that would cause a default on day one under the loan documents. That's another opinion that we will often ask for. That the interest is not usurious. A lot of times this is just a simple Google of a statute. Every state has its statute. I think it's 19% in Illinois, which is a usury rate. And our loans, even in our current economic climate, don't go up to 19%. And that any filings of UCCs, or I guess we would include mortgages and assignments, will be sufficient to perfect the bank's lien upon recordation. So that's, again, a simple one. It's more to the form rather than substance of the documents. We're not going to ask you to make any opinions about, is the collateral description correct? Is the borrower's name spelled right? Not substantive, but just take a look at this document. Does it meet the local requirements or the state requirements for perfection? So as I said, a little bit intimidating on the opinion letters, but a very crucial part of the transaction. If you have never written an opinion letter, you should ask me, and I will anonymize one from a prior similar transaction with all the opinions that I'm looking for, and I'll send it over to you for you to just use as a form. And most of us will do that. I'm not going to send you any details from prior transaction, but in terms of what I'm looking for, I'm willing to work with you. And truthfully, I want you to use my form. If you just fill it out as I want, then I don't have to negotiate with you. You may have changes, that's fine too, but most of the time we're willing to work with you because a good result for our client is closing the deal, and a good result for your client is the same thing. And so again, I would treat it as a collaborative process. It can be a little bit daunting, especially when I send you a full batch of documents and it's over 400 pages, but I'm not looking for you to do it overnight or even within a week. I want you to take your time. I want you to make your client, the borrower, feel good about the whole process. And I want it to be correct as well. So if you do catch things, again, I haven't come across a lending attorney that will bristle or take offense to those types of things. Always ask, because you don't know what we might agree to.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.